Justice Kavanaugh concurring. The plaintiffs here sought preliminary injunctions against enforcement of the President's executive order on birthright citizenship. The district courts granted universal preliminary injunctions, that is, injunctions prohibiting enforcement of the executive order against anyone. Under the court's holding today, district courts issuing injunctions under the authority afforded by the Judiciary Act of 1789 may award only plaintiff-specific relief. I join the court's careful and persuasive opinion, which will bring needed clarity to the law of remedies. To be sure, in the wake of the court's decision, plaintiffs who challenge the legality of a new federal statute or executive action and request preliminary injunctive relief may sometimes seek to proceed by class action under Federal Rule of Civil Procedure 23b. 2. And ask a court to award preliminary class-wide relief that may, for example, be statewide, region-wide, or even nationwide. AARP v. Trump, 2025, per curiam, Califano v. Yamasaki, 1979. And in cases under the Administrative Procedure Act, plaintiffs may ask a court to preliminarily set aside a new agency rule. See, for example, West Virginia v. EPA, 2016. See also Corner Post, Incorporated v. Board of Governors, 2024, Kavanaugh concurring. But importantly, today's decision will require district courts to follow proper legal procedures when awarding such relief. Most significantly, district courts can no longer award preliminary nationwide or class-wide relief, except when such relief is legally authorized. And that salutary development will help bring substantially more order and discipline to the ubiquitous preliminary litigation over new federal statutes and executive actions. I write separately simply to underscore that this case focuses on only one discrete aspect of the preliminary litigation relating to major new federal statutes and executive actions, namely, what district courts may do with respect to those new statutes and executive actions in what might be called the interim before the interim. Although district courts have received much of the attention and criticism in debates over the universal injunction issue, those courts generally do not have the last word when they grant or deny preliminary injunctions. The courts of appeals and this court can, and regularly do, expeditiously review district court decisions awarding or denying preliminary injunctive relief. The losing party in the district court, the defendant against whom an injunction is granted, or the plaintiff who is denied an injunction, will often go to the Court of Appeals to seek a temporary stay or injunction. And then the losing party in the Court of Appeals may promptly come to this court with an application for a stay or injunction. This court has therefore often acted as the ultimate decider of the interim legal status of major new federal statutes and executive actions. See e.g. Ohio v. EPA 2024, Danko Laboratories LLC v. Alliance for Hippocratic Medicine 2023, National Federation of Pendant Business v. OSHA 2022 per curiam, Alabama Association of Realtors v. Department of Health and Human Services 2021 per curiam. See also Labrador v. Poe 2024, Kavanaugh J. concurring in grant of stay. After today's decision, that order of operations will not change. In justiciable cases, this court, not the district courts or courts of appeals, will often still be the ultimate decision-maker as to the interim legal status of major new federal statutes and executive actions. That is, the interim legal status for the several-year period before a final decision on the merits. Kavanaugh Concurrence, Section 1. The court's decision today focuses on the interim before the interim, the preliminary relief that district courts can award and courts of appeals can approve. For the generally weeks-long interim before this court can assess and settle the matter for the often years-long interim before a final decision on the merits. To appreciate the broader context surrounding today's decision, it is important to understand this court's role in preliminary litigation of this sort. The basic scenario in these kinds of applications to this court is by now familiar. Congress passes a major new statute, or the executive branch issues a major new rule or executive order. The litigation over the legality of the new statute or executive action winds its way through the federal courts, and that litigation may meander on for many months or often years before this court can issue a final ruling deciding the legality of the new statute or executive action. In the meantime, various plaintiffs may seek preliminary injunctions, sometimes in many different district courts, and a government defendant against whom a preliminary injunction is granted, or a plaintiff who is denied a preliminary injunction, may seek a temporary stay or injunction in the Court of Appeals and then in this court. That preliminary injunction litigation, which typically takes place at a rapid-fire pace, long before the merits litigation culminates several years down the road, raises a question. What should the interim legal status of the significant new federal statute or executive action at issue be during the several-year period before this court's final ruling on the merits? That interim status question is itself immensely important. The issue of whether a major new federal statute or executive action is enforceable during the several years while the parties wait for a final merits ruling raises a separate question of extraordinary significance to the parties and the American people. Labrador v. Poe, 2024, Kavanaugh, J., concurring in grant of stay. The interim status issue, in turn, raises two other critical questions. Should there be a nationally uniform answer on the question of whether a major new federal statute or executive action can be legally enforced in the often years-long interim period, until this court reaches a final decision on the merits? If so, who decides what the nationally uniform interim answer is? First, in my view, there often, perhaps not always, but often, should be a nationally uniform answer on whether a major new federal statute, rule, or executive order can be enforced throughout the United States during the several-year interim period, until its legality is finally decided on the merits. Consider just a few of the major executive actions that have been the subject of intense preliminary injunction or other pre-enforcement litigation in the past 10 years or so, under presidents of both political parties. They range from travel bans to birthright citizenship, from the Clean Power Plan to student loan forgiveness, from the OSHA vaccine mandate to the service of transgender individuals in the military, from Title IX regulations to abortion drugs. And the list goes on. Those executive actions often are highly significant and have widespread effects on many individuals, businesses, governments, and other organizations throughout the United States. Often, it is not especially workable or sustainable or desirable to have a patchwork scheme, potentially for several years, in which a major new federal statute or executive action of that kind applies to some people or organizations in certain states or regions, but not to others. The national reach of many businesses and government programs, as well as the regular movement of the American people into and out of different states and regions, would make it difficult to sensibly maintain such a scattershot system of federal law. Second, if one agrees that the years-long interim status of a highly significant new federal statute or executive action should often be uniform throughout the United States, who decides what the interim status is? The answer typically will be this court, as has been the case both traditionally and recently. This court's actions in resolving applications for interim relief help provide clarity and uniformity as to the interim legal status of major new federal statutes, rules, and executive orders. In particular, the court's disposition of applications for interim relief often will effectively settle, de jure or de facto, the interim legal status of those statutes or executive actions nationwide. The decision today will not alter this court's traditional role in those matters. Going forward, in the wake of a major new federal statute or executive action, different district courts may enter a slew of preliminary rulings on the legality of that statute or executive action. Or alternatively, perhaps a district court or courts will grant or deny the functional equivalent of a universal injunction, for example, by granting or denying a preliminary injunction to a putative nationwide class under Rule 23(b)(2), or by preliminarily setting aside or declining to set aside an agency rule under the APA. No matter how the preliminary injunction litigation on those kinds of significant matters transpires in the district courts, the courts of appeals in turn will undoubtedly be called upon to promptly grant or deny temporary stays or temporary injunctions in many cases. And regardless of whether the district courts have issued a series of individual preliminary rulings, or instead have issued one or more broader class-wide or set aside preliminary rulings, the losing parties in the courts of appeals will regularly come to this court in matters involving major new federal statutes and executive actions too. If there is no class-wide or set-aside relief in those kinds of nationally significant matters, then one would expect a flood of decisions from lower courts, after which the losing parties on both sides will probably inundate this court with applications for stays or injunctions. And in cases where class-wide or set-aside relief has been awarded, the losing side in the lower courts will likewise regularly come to this court if the matter is sufficiently important. When a stay or injunction application arrives here, this court should not and cannot hide in the tall grass. When we receive such an application, we must grant or deny. And when we do, that is, when this court makes a decision on the interim legal status of a major new federal statute or executive action, that decision will often constitute a form of precedent, de jure or de facto, that provides guidance throughout the United States during the years-long interim period until a final decision on the merits. Kavanaugh Concurrence, Section 2. It is sometimes suggested, however, that this court should adopt a policy of presumptively denying applications for stays or injunctions, even applications involving significant new federal statutes or executive actions, regardless of which way the various lower courts have ruled. That suggestion is flawed, in my view, because it would often leave an unworkable or intolerable patchwork of federal law in place. And even in cases where there is no patchwork, for example, because an application comes to us with a single nationwide class action injunction, what if this court thinks the lower court's decision is wrong? On student loan forgiveness or the Clean Power Plan or mifepristone or the travel bans, for example, should we have a rule of presumptively denying relief, thereby allowing erroneous injunctions or erroneous denials of injunctions of major new statutes and executive actions to remain in place for several years, and thus severely harming the government and would-be beneficiaries of or regulated parties under those new statutes and executive actions? I think not, and this court's actions over the years reflect that the court thinks not. Unless and until this court grants or denies an application for stay or injunction, tremendous uncertainty may surround the interim legal status of the new federal statute or executive action throughout the country. The statute or executive action may be in effect in some places but not others, for some businesses but not others, for some Americans but not others. That temporary geographic, organizational, and individual variation in federal law might not warrant this court's intervention in run-of-the-mill cases, which is why it makes sense that this court denies applications for interim relief when the court is unlikely to later grant certiorari. C. Does 1-3 v. Mills, 2021, Barrett J. concurring in denial of application for injunctive relief. But in cases involving major new federal statutes or executive actions, uniformity is often essential or at least sensible and prudent. In those kinds of cases, disuniformity, even if only for a few years or less, can be chaotic, and such chaos is not good for the law or the country. One of this court's roles in justiciable cases is to resolve major legal questions of national importance and ensure uniformity of federal law. So a default policy of offloading to lower courts the final word on whether to greenlight or block major new federal statutes and executive actions for the several-year interim, until a final ruling on the merits would seem to amount to an abdication of this court's proper role. Some might object that this court is not well equipped to make those significant decisions, namely, decisions about the interim status of a major new federal statute or executive action, on an expedited basis. But district courts and courts of appeals are likewise not perfectly equipped to make expedited preliminary judgments on important matters of this kind. Yet they have to do so, and so do by law. Federal courts are open and can receive and review applications for relief 24/7, 365. See 28 U.S.C. Section 452. All courts of the United States shall be deemed always open for the purpose of fling proper papers and making motions and orders. And this court has procedural tools that can help us make the best possible interim decision in the limited time available. Administrative stays, additional briefing, amicus briefs, oral argument, certiorari before judgment, and the like. On top of that, this court has 9 justices, each of whom can and does consult and deliberate with the other 8 to help the court determine the best answer, unlike a smaller 3-judge court of appeals panel or 1-judge district court. And this court also will have the benefit of the prior decisions in the case at hand from the Court of Appeals and the district court. Some might argue that preliminary disputes over the legality of major new statutes and executive actions can draw this court into difficult or controversial matters earlier than we might like, as distinct from what happens on our slower-moving merits docket. That is an understandable concern. But when it comes to the interim status of major new federal statutes and executive actions, it is often important for reasons of clarity, stability, and uniformity that this court be the decider. And members of the court have life tenure so that we can make tough calls without fear or favor. As with the merits docket, the court's role in resolving applications for interim relief is to neutrally referee each matter based on the relevant legal standard. Avoiding controversial or difficult decisions on those applications is neither feasible nor appropriate. Some might also worry that an early or rushed decision on an application could lock in the court's assessment of the merits and subtly deter the court from later making a different final decision. But in deciding applications for interim relief involving major new statutes or executive actions, we often have no choice but to make a preliminary assessment of likelihood of success on the merits. After all, in cases of that sort, the other relevant factors, irreparable harm and the equities, are often very weighty on both sides. See Labrador v. Poe, 2024, Kavanaugh J., concurring in grant of stay. Moreover, judges strive to make the correct decision based on current information, notwithstanding any previous assessment of the merits earlier in the litigation. It is not uncommon to think and decide differently when one knows more. This court has done so in the past. See West Virginia Board of Education v. Barnett, 1943, and undoubtedly will continue to do so in the future. To reiterate, this court should not insert itself into run-of-the-mill preliminary injunction cases where we are not likely to grant certiorari down the road, but determining the nationally uniform interim legal status for several years of, say, the Clean Power Plan or Title IX regulations or mifepristone rules is a role that the American people appropriately expect this court, and not only the courts of appeals or district courts, to fulfill. The volume of preliminary injunction and other pre-enforcement litigation over new federal laws and executive actions coming to this court has been growing in recent years. That trend is in part the result of the increasing number of major new executive actions by recent presidential administrations of both political parties that have had difficulty passing significant new legislation through Congress. Meanwhile, applications for stays or injunctions in capital punishment cases, election disputes, and other time-sensitive matters, including numerous COVID-19 related disputes in the few years beginning in 2020, have also continued to come to this court on a steady basis, as they traditionally have, Although the volume of applications has increased, the court's responsibility for deciding consequential applications for stays or injunctions is not new. See example. West Virginia v. EP 1126-2016, temporarily enjoining Clean Power Plan. Purcell v. Gonzalez 2006, per curiam, vacating injunction pending appeal regarding state voter ID law. Rubin v. United States 1998, Rehnquist in Chambers, denying stay pending certiorari of order enforcing subpoenas to Secret Service agents regarding their observations of the president. Schlesinger v. Holtzman, 1973, Marshall in Chambers, staying district court's injunction that had ordered a halt to bombing in Cambodia. Youngstone Sheet and Tube Co. v. Sawyer, 1952, after expedited oral argument, affirming district court's preliminary injunction that proscribed seizure of steel mills by government. Rosenberg v. United States, 1953, vacating stay of execution of the Rosenbergs. Today's decision on district court injunctions will not affect this court's vitally important responsibility to resolve applications for stays or injunctions with respect to major new federal statutes and executive actions. Deciding those applications is not a distraction from our job. It is a critical part of our job. With that understanding, I join the court's opinion in full.